the violence and threats of violence certainly informs what is the risk that the facility faces in Portland if you remove all of the protective forces that we've had to divert to contain that situation. So I think that is one of the key errors here that the district court judge made, is taking this blinkered view of the statute, where we're only looking at what's happening in Portland in the days or weeks ahead of the federalization. And to your question about why is what's going on in the rest of the country relevant, that's because the government only has limited protective services at its disposal. They've had to call in 100 plus 115 federal protective services officers have been brought in from other locations and deployed to provide 24/7 protection of the Portland facility. And our declarations below explain why that is neither safe nor sustainable, that they're not equipped to deal with that.
How often is that done?
Speaking of sustainable, those folks have gone home, am I right?
No. Some of them have gone home. There are still many of them deployed there. And certainly the president can take into account the fact that they are being pulled away from their normal duty stations. They are being tied down and are not available to address the rising violence that's occurring in other cities focused on thwarting enforcement of the immigration laws. And
how often does that happen where forces are reallocated like this? Is that unusual or is that regular?
I don't have historical data on this, but I have to imagine that a diversion of this magnitude is quite irregular. If you look at the declaration from the deputy director of FPS, he says quite clearly that we are not equipped to deal with this kind of ongoing, sustained unrest. While the officers are expected to be able to respond to emergencies, they are not expected to work 12 hours a day, 7 days a week, which has become the norm. That declaration states that is neither safe nor sustainable. And that's, I think, something that the president can surely take into account in analyzing whether the regular forces are able to execute the laws. Judge Graber, to go back to your reference to the situation in Los Angeles, I think there are two main differences between what's happening in Portland and what's happening in Los Angeles, and neither is material to whether the president had a colorable basis, in fact, in law to invoke the statute here. Of course, one main difference is the violence was on a significantly larger scale in Los Angeles, but of course that was addressed here by the calibrated nature of the calling up of the Guard. Only 200 members of the Oregon National Guard were called up compared to the 4,000 that were called up.
How many guardsmen were actually deployed? I know that it said 3,000 or 4,000 could be called up, but how many were actually deployed in Los Angeles?
I don't know the number. I think it was in the thousands that were actually deployed. It's significantly down now. My understanding is it's down in the low hundreds at this point. But the second difference that I wanted to focus on in Los Angeles is the president there made the decision to activate the Guard immediately to deal with the acute threat. Whereas here, we first tried to manage the situation with the regular forces, and the president only activated the National Guard after it became clear that that was neither safe nor sustainable. And the way the district court judge looked at this, where she refused to consider any of the evidence from June or July or earlier in the summer and didn't dispute that the conditions may have been met to activate the Guard then, effectively penalizes the president for using the National Guard as a last resort rather than as a first resort, and I think creates a bad incentive to do precisely that.
I have one, what I think might be my final question to you, which is really for you and not for other counsel, and that is with respect to the things that the district court did consider. Are there any factual findings that you contend are clearly erroneous? And if so, precisely which ones?
I think the answer to that, Judge Graber, is no, because I don't think there is a dispute about any of the relevant facts. I think the question is whether the undisputed facts, particularly the undisputed facts in the government's declarations, suffice to establish a colorable basis for invoking section 12406.
So let me just be sure I understand your answer. You are not contending that any of the district court's factual findings are clearly erroneous. You're contending that she should have considered additional facts or come to a different conclusion, but you're not contending that any of the findings she made are clearly erroneous. Is that a fair summary?
At least not insofar as her stating that X event occurred on Y date. We're not disputing any of that. If we're getting beyond whether certain facts occurred to what's, sort of the risk that's presented by that and whether that risk suffices to invoke the statute, I think there we're not in the circumstance where we have a factual finding. That's application of law to facts.
So
and
is the assessment of risk as distinct from the effect of the amount of risk, is that a factual finding? In other words, if someone, this is just a hypothetical, if someone says the person was driving at 8 miles an hour and that does not present a serious risk of running over a pedestrian, is the assessment of risk that stems from the underlying fact a factual conclusion or a legal conclusion?
I think in certain circumstances, an assessment of risk could be a factual conclusion. I don't think we have that here. I think what the district court said is that future risk is simply irrelevant, that you only can look to what's actually happening. I think that clearly has to be wrong because future risk dictates what regular forces have to do now to counteract that future risk. And that is why we've had to have so many protective services officers at this facility 24/7 in a way that's neither safe nor sustainable.
Can I ask about, you've made a review, and by the way, I know you've asked for time. We'll give you enough time to answer all of our questions. It may take each of you over the allocated times. I wanted to ask about the reviewability because you've made an argument that this is just not reviewable by the courts. And I understand your argument to be based on Martin, which has some pretty strong language that this is expressly within the discretion of the president. Newsom didn't adopt that argument. To what degree are we bound by Newsom that this is reviewable?
So I have not found any circuit precedent that speaks squarely to that question. In the East Bay case, the court said that a published panel stay decision may be binding on future panels as to the same issue. I think I can take that off the table. We have preserved that argument. We do think it's correct. I will certainly be taking a run at the Newsom merits panel in a couple of weeks to try to persuade them that that's the one part of their opinion I think they got wrong. But for purposes of resolving this motion today, I think you can take that as the law of the circuit and ask whether we meet the very deferential standard of review that the Newsom state panel applied.
Can I just ask one follow-up question on that, though? Because this is something that I would be interested in your view of the history of the statutes, because in 1792, there was some review.
Protect your dreams.
It didn't look like it was judicial,
under our
review,
roof.
but there had to be a pre-clearance
American Family
by a
Insurance.
justice of the Supreme Court. Then in 1795, that provision was taken out. In 1831, the statute expressly gave total discretion to the President of the United States. And then in our current statute, 1903, that total discretionary language was taken out. Maybe you'll make that argument in the Newsom case, but I didn't see Newsom walk through that statutory history. And it strikes me that suggests that there might be some reviewability here based on the change between the 1831 statute and the 1903 statute.
So the reason I don't think that's right, Judge Nelson, is because I think you should compare the language of the statute as it exists today to the language of the statute in Martin and subsequently in Luther versus Borden. And it's the exact same language. The statute is structured the exact same way. It's whenever, in a set of conditions, the president may activate the National Guard. And the court in Martin said that statute vested in the president's sole and exclusive judgment whether the statutory preconditions were met. And to the extent Martin left any uncertainty about whether that was binding just on subordinate military officials or instead also on the courts, I think that was cleared up in Luther versus Borden, where the court quite clearly applying Martin said that that was conclusive even on the courts.
So, and just one, maybe you've already answered this, but so Martin was binding in 1831. So would that language that was expressly put in the 1831 statute, in your view, would have been superfluous, and removing superfluous language in 1903, in your view, just had no effect?
I think that's right. I mean, we don't know why that language may have been removed. They may have removed it because they thought it was unnecessary in light of the existing precedent from Martin and Luther, and Congress enacted that statute in 1903 against the backdrop of those precedents. And ordinarily, we presume that when Congress takes language that has received a construction from the United States Supreme Court and replicates it in a new statute, it imports that settled construction of the statute. And for that reason, I think both as a matter of vertical stare decisis, a lower court is bound by Martin and Luther, and that is the correct interpretation of the statute because of that principle of interpretation. But again, I don't think this panel needs to get into that here. I think the likelihood of success on the merits in this case comes down to two questions that I'd just like to crystallize for the court. One of them about the law, one of them about the facts. The legal question is whether Section 12406 colorably authorizes the president to call up the National Guard when violence and threats of violence directed at federal officials and facilities has significantly impeded federal law enforcement and required an unsustainable diversion of the regular forces in order to contain it. That's the legal question. The factual question is whether the facts of record here create a colorable basis to believe that that is the situation in Portland. And I think the answer to both of those questions is quite clearly yes.
I'd like to ask you a couple of questions. One is to go to the factual issues. There was a statement in Deputy Director Cantu's declaration that there are 776 Federal Protective Service officers and only 497 are inspectors. But it wasn't clear to me what that means. Does that mean that only 497 officers are available nationwide to protect federal property? Is there a distinction between the 776 and the 497?
I had understood, and I would have to go back and look specifically at the language, but my recollection and the way I'd understood that was those are the officers who have the requisite training to be able to deal with these sort of civil unrest and violent protests, and the others do not.
All right. So when he says 115 Federal Protective Service officers were deployed, you're saying that that means out of the 497 available to protect the federal building, which means roughly 25% of the officers available nationwide were deployed to Portland.
That's how I understood it, Judge Beatty. And I think that's why he also said that this is just not sustainable.
So the other question I have is more about our procedural posture. You saw the order on the administrative stay, and there is a second TRO that the district court entered after the first and after your notice of appeal was filed. And you are here before us now asking for a stay pending appeal. But don't we have the same issue that even if we were to stay the first order, the second is still in place?
There is that same issue, and I do want to be clear that the administrative stay that was granted doesn't, from our perspective, take the time pressure off getting a full stay pending appeal.
Often polarized, and boil them down to the key insights for you.
So that
Today
we can
we're digging
then
into a
immediately
movement
go
that's
to the
been around
district
for
court and say, in
decades,
light
but
of that,
has really
the district court should dissolve that second TRO, because the second TRO rests on the exact same basis as the first TRO. So if this court grants a stay pending appeal concluding that interim relief here was not warranted because the government's likely to prevail on the merits, or because there's no irreparable harm, or because of the sliding scale, or whatever, then I would expect the district court to immediately dissolve that second TRO. And if the district court did not, then at that point, I'm confident that we would be back up here again.
Well, as things...
Would you have run the time? I mean, you haven't even filed a notice of appeal. What if we...
We're not going to run out of time to file a notice of appeal. That's 60 days. The TRO is in effect for 14. So
I have a follow-up question to that, though. We are to decide on the state of the world as it exists today. And as it exists today, one of the things that you have the burden to demonstrate here, I think, is harm, that there's harm. And if the federalized National Guard members cannot be deployed, which is the state of affairs today, what is the harm that you are suffering? I mean, even if we grant the stay right now, I guess I have trouble seeing how there is harm if nothing changes.
Well, the harm certainly is that we cannot deploy the Guard members to address the risks of violence.
That's right, but that's not because of this case at this point. It's because of the second TRO.
It's because of the terms of both of the TROs, which rest on precisely the same reasoning. And if the panel thinks that in order to establish irreparable harm, we need to bring that second TRO up for appeal now and get it consolidated, we can certainly do that. Our judgment had been that we didn't need to burden the court with that, because if the court grants a stay pending appeal here, that should be binding on that second TRO, and it should be dissolved by the district court. And so that would redress our irreparable harm.
So can I ask about the 14-day nature? That's also different than California. California didn't have the district court did not put the 14 days in there. Does that mean we need to rule before the expiration of that? I mean, do we know whether the district court is going to extend that? Can the district court extend it? If we don't rule within 14 days, does this all become moot? What's your view on all that?
So the district court has scheduled a hearing, I believe, on October 17th, which is the day before the TRO expires on October 18th, to decide whether or not to extend the TRO for an additional 14 days. If the TRO does expire either on the 18th or after it's extended for another 14 days, that would render this appeal moot. Hopefully, our view is that the panel should grant a stay pending appeal well in advance of any of that. And that would give guidance then to the district court. The court has also scheduled a preliminary injunction hearing for the end of the month on October 29th. And I think if the court granted a stay pending appeal here, the court's analysis of the likelihood of success on the merits and the balancing of the equities would inform the preliminary injunction analysis and hopefully preclude the grant of a preliminary injunction, or if not, at least require the district court to stay any preliminary injunction that's granted. Otherwise, we're going to be right back up here repeating everything that we've just done.
Okay. Any other questions by my colleagues?
No.
Thank you. We'll still give you 3 minutes for rebuttal.
Thank you.
May it please the court and counsel, Stacey Chaffin on behalf of the plaintiffs. The president's 12406 determinations are entitled to great deference, but that deference has a limit, and that limit is this case. Where the president's determinations are untethered from reality, they cannot represent a colorable assessment of the facts within a range of honest judgment. I'd like to take first, Judge Graber, your question about what document represents the president's determination. And the answer is that we don't know. It's very unclear what document the president relied on to authorize the federalization of the National Guard. The two documents that we do have are the June 7th memorandum, which was issued in response to the escalating ICE protests in Los Angeles. That memo is specifically referenced in the September 28th memorandum from Secretary Hegseth that mobilized the Oregon National Guard. That memo that was issued not only relies on the June 7th memo, it references it, and then it also attaches the June 7th memo. But that memo was issued 4 months prior.
But you're not suggesting, I mean, you have raised an APA claim, but you're not suggesting that we need some formal order that represents final agency action by the president, are you?
Not at this time. And we're not making arguments regarding the form of the order itself. But if the president was relying on the June 7th memorandum, that was both not relating to Portland, and it's exceptionally stale by the time that the troops or the National Guard was actually federalized in September. There's a significant deficit of time.
So under your theory, then we can't consider any of the facts because the president didn't mention them? I mean, I don't know what the impetus for your argument is on that.
Well, if the president, the June 7th memorandum, if that is the basis for the federalization of the national troops, it has nothing to do with Portland. And it only had to do with the circumstances that were happening at that time in June.
Counsel suggested, though, that the social media post that said there's war in Portland and go forth and fix it is sort of an addendum, if you will, or a direction to apply the June 7th memo to Portland. What's your response to that?
Certainly, the statute doesn't identify for us the form that the president's determination needs to take. And if the defendants are relying on a social media post, that social media post still isn't, it doesn't represent a colorable assessment of the facts within the range of honest judgment. Within that document, the president references Portland as war-ravaged, which we all know is not accurate. And then it also calls Portland under siege, also an inaccurate statement. Because these are inaccurate statements, they can't form the basis of a colorable argument under 12406.
Well, that may be true, counsel, but you're not denying. I mean, what we heard from your opposing counsel is there's really not a lot of dispute on the facts. There might be dispute as to which facts are relevant. Do you think there's a dispute of facts as to what's happened in June, July, August, September? I mean, are there points in time where you think you have a disagreement on what's actually happened with opposing counsel?
I think we disagree with the framing, but I would direct this court to the district court's findings regarding those facts. The district court found that the Portland ICE facility protests were small, less than 30 people, largely sedate and generally peaceful. Okay, hold on. That's clearly erroneous because there's clearly been protests that were above 30. I mean, unless you're trying to limit it to certain time periods. We have evidence in the record that there were protests as much as 200. It was generally small. And
I think there were 3 instances where it was large over that time period. But when we're talking about how to, as you say, frame the facts, can you go on to answer my other question, which is what is a rebellion, and what is the standard that we should be applying?
A rebellion is an open, organized, or armed resistance to an established government or an attempt to change the government or the leader, usually through violence. That is the appropriate definition that this court should adopt in this case.
And where does that come from?
The older definitions in Webster's. And I would highlight for the court that the first time that rebellion was added was in 1861, and that was shortly after the Confederacy declared independence and the first shots were fired at Fort Sumter. And it's with that context in mind that we should interpret the word rebellion. And it certainly isn't.
What about the Whiskey Rebellion?
The Whiskey Rebellion certainly comes into play as well, but I think
could that inform our definition of rebellion, or was that the president acted under some different provision?
I'm sorry, I don't know the exact answer to that question, but I can say that the defendant's proposed definition here is so broad that it could potentially encompass a significant amount of protected speech and protest activity. In their briefing,
I mean, my concern is and that may be true, but your definition and perhaps the definition applied by the district court seems so narrow that it doesn't even comport with the vast exercise. I shouldn't say vast, it hasn't been that many, but with those incidences where the National Guard has been used or the militia has been used, it wouldn't satisfy the rebellion prong in those either.
And I can't specifically point to the situations where the rebellion prong has been utilized, but I do know that in Newsom, this court identified that both invasions and rebellions are unusual and extreme emergencies that threaten the normal operation of civil government. So it needs to be this significant, intense, large-scale situation that really it has such a large impact on the fabric of the country. I mean, if we're comparing it to an invasion from a foreign power, that's something that goes to the heart of the safety of our country. And when it explains also why the president has deference in these circumstances, that he's expected to respond to sudden emergencies that are upon great occasions and under circumstances which may be vital to the existence of the Union. It is under that framework that we define the phrase.
We do a little trolling. It's called we do a little trolling.
And if I could.
Oh, I'm sorry. I was going to ask you to move to my question concerning.
We do a little trolling. It's called we do a little trolling.
Is relevant, particularly in terms of time. How current the proclamation or.
We do a little trolling. It's called we do a little trolling.
Of June 7th. Refers to current circumstances that would justify mobilization. So what, in your view, is the appropriate time frame to be looking at for determining whether the statutory standard is met?
From a kind of larger perspective, that really is going to depend on the circumstances. And we're not asking this court to create a very specifically defined set of factors that need to be evaluated in every case. But in this case, when the president has authorized the federalization of the National Guard in Oregon, we're asking this court to look at the circumstances around when that happened.
So do we look from June 7th forward, or do we look only at September or something else?
It would make sense it's reasonable to look at around the time period when the National Guard was actually federalized. What happened in June, and we acknowledge
Isn't June around the time period of when the National Guard was federalized?
It was 4 months prior, and that is significant because there can be, and there was, a very large delta between what was going on in June and what was actually going on when the president.
So could the president have, in your view, nationalized the Guard in June?
I think we'd be having a different conversation, and it would certainly be a closer call. But
and so the president loses his right to do that, in your view, because he waits to see how things turn out on the ground.
I think in the moment, the president can make the decision to manage the situation with the normal forces. And here what we have is even that situation in June. I point the court to, I think it was June 14th is probably the worst of the circumstances that happened. And that day, the threat of violence from the protesters lasted 2 hours. And it's with the use of normal forces that they could stop the kind of incursion of the protesters, push them back, and everyone kind of had the safety that was necessary with using the normal forces. That stands in stark contrast to what happened in California. In California, there was a span of 2 days where they had consistent and increasing protest activity, where they were penning down officers, throwing concrete chunks. They used dumpsters as battering rams to breach the facility. And the next day, the confrontation lasted for another 7 hours. Protesters boxed in officers, threw Molotov cocktails, mortar-style fireworks, rocks. They blocked traffic and burned a vehicle.
But that's a little bit of the irony here, is that because the president acted in June in LA, I mean, I don't know that we have I don't know, but it seems like we don't have the same level of violence going on in LA right now. But the president acted when there was violence, and you're saying, well, if you don't hit it within a narrow window, you lose your right. That just seems unnaturally constrained. I mean, what the president did was bring in 115 FPS officials, and that has quelled the violence to some degree, it seems. But it hasn't abated it. I mean, there's still violence going on, right?
Well, what we have is the finding from the district court that the federal law enforcement officers, unaided by military forces, were capable of not only quelling the violence in June, but also preventing it through September. These are
I'd like to ask you about some specific facts that I don't think are disputed. So the facility was forced to close. It was inoperable for almost a month, from June 13th to July 7th. And the declarations from the director of the Federal Protective Services and the field operations director from DHS state that the facility only reopened because of a surge of 115 Federal Protective Services officers to Portland, right? So those are facts that occurred, but that the district judge didn't consider because she apparently viewed them as out of time, that this had occurred. Are those not facts that are relevant to just for the president to determine the threat and whether there's a threat to DHS being able to enforce the 400 laws it's tasked with enforcing? I mean, they couldn't operate a facility. I don't know that that ever happened in LA. There were attempts to breach a facility. Here, a facility was actually closed for almost a month. And the record includes more than one, at least 2 attempts to burn the building down and vandalizing the building so that it's difficult for the officers to move in and out of the building and increases danger. And the building is now currently boarded up, and the city has told DHS they have to remove the boards. So that means the facility presumably will be inoperable again. So why is all of that irrelevant to the president's decision to federalize the National Guard?
Well, I'd like to push back a little bit on the reframing here. What we have is in early June, the facility was closed for 2 weeks.
During specific dates, June 13th through July 7th. That is not 2 weeks. It's about 3.5. And I think it's properly characterized as nearly a month. But the facility was indeed closed, but the district judge didn't consider it because it was in June. So if I understand your position, only things that happened like September 24th, 25th, 26th, I mean, a very small window of time. Those are the only days that the president could have legally considered when deciding whether there was a threat to the enforcement of law?
Well, if we're talking about the third prong, the inability to execute laws with the regular forces, that is a current temporal requirement.
Okay, so what is your basis for saying that? Because I didn't see the Newsome, but what is it, where is it that it says there's a they talked about the facts there, which happened to include events that had occurred in the preceding days. Here, the president relied on, according to the declarations that have been presented, on the facts leading up to the order from June, July, and August and September. So there's a period of a few months where things were unfolding on the ground. And what I think you're saying is we can't consider any of that it should only be a few days. But what is your basis for saying that?
The text of the statute is the basis. So if we look at the third prong, it says the president is unable. That is a current inability to execute with the regular forces the laws of the United States.
And is that a day by day? So that, I mean, if we said forces are allowed, and then what, we come back the next day and say, oh, well, you got it under control. Now they're not allowed. Then it goes back up. Oh, they're allowed. I mean, it just seems like such a tortured reading of the statute. I mean, I'm not even sure President Lincoln would have been able to bring in forces when he did, because he'd have to wait. You know, if he didn't do it immediately after Fort Sumter, your argument would be, oh, things are okay right now. It just seems. What
is the effect of the June 7th authorizations statement that the National Guard should be performing federal functions at locations where protests against these functions are occurring or likely to occur based on current threat assessments? So does that limit how we or how Secretary Hegseth would have had to consider what was currently appropriate?
Yes, if the June 7th memorandum is part of this court's evaluation of the president's determination, it is limited by the current situations. And I would also, again, just direct this court back to the text of the statute, which there is an expectation that the circumstances are going to be evaluated as they happen. And that makes sense because these are emergencies, these are unusual circumstances that would immediately require the president's attention and response. If these are circumstances that are so significant that they could challenge kind of the fabric of our nation, the threat of invasion, they need an immediate response. And there isn't an attempt to penalize the president for waiting. There is a requirement that the circumstances as they happen be so significant that we need to federalize the National Guard. And
actually, for number 3, I don't think that's true. For 3, it says the president with regular forces can't execute the laws. I mean, I'm sort of trying to figure out how a district court of any nature is supposed to get in and question whether the president's assessment of executing the laws is right or wrong.
Well, this court has already concluded that there is judicial review of that determination.
I understand that, but it's also great deference. And I mean, here, it has to be colorable. And so when the president comes in and says, look, we've got 115 FPS forces that aren't normally in Portland and we've had to move them, this is straining our ability to execute the laws. I don't understand how you can question the behind the scenes to say, oh, no, that can't be right. I mean, we don't have a view into what laws are trying to be executed or how they're being impinged. But why isn't that colorable?
Because it's not true. Unfortunately,
it's not true that 115 FPS forces have been there since it reopened in July?
Well, we do have in the record that a lot of the surge forces were returned before the president's announcement. So I understand that these declarations kind of, they discuss the worst of the circumstances, which I understand, but they're also written by supervisors who don't work in Portland. They're from outside of the state.
I have absolutely no idea. The district court said the same thing. I have absolutely no idea what that has to do with anything.
Because we would direct.
You want to focus on what's going on outside and it doesn't rise to this level. But that's not what the statute says. The statute says the president can't execute the laws. That's an internal decision making. And whether there's a ton of protests or low protests, they can still have an impact on his ability to execute the laws.
But this court has said that minimal interference isn't enough to raise to the level of an inability to execute laws. And that's what we have here. We have, yes, in June, there were more intense protests, but we have the district court identifying that the normal forces were able to manage those protests, which is within the job responsibilities of FPS generally. This is what we do. They do. You have from the declaration.
But that just seems to be the wrong analysis. And the district court did this. The district court said, well, look, people who acted violently were arrested, so everything's good. But that's not what the statute says. The statute says the president can't execute the laws. And I'm just trying to figure out why we're giving, district courts the ability to say, well, this is what I see on the outside, so therefore I'm going to transfer that onto what's going on behind the scenes. And we have declarations that say that it is impeding their ability to perform their function.
We have declarations that say we're short-staffed. We're having administrative difficulties because we don't have enough people. That is not a reason to bring the military into the streets of Portland or any other city in the United States. There needs to be something more than a deficit of employees to raise to the level of such a significant incursion into the sovereignty of a state. It needs to be more, and this is the case.
Into the streets, the deployment is limited just to the protection of federal personnel and federal property. So I saw quite a bit of that language in the motions suggesting that National Guard members would be deployed to patrol the streets of Portland, which is I don't think the government has ever said that that is the intent. The idea is to protect the building so that it can remain open.
But if
federal personnel, but
what we do have, though, is a history of a very expansive and almost strained reading from the government of the district court orders. And it would, because this authorization is to protect any federal government location, any federal personnel go throughout the city to execute whatever their mission is. And there's no, as of the drafting, there's no specific limitation that they're going to only be in.
But why would we enjoin it up front? I mean, I want to be clear. I'm very sensitive to the slippery slope argument that's being made here and the slippery slope argument that's being made in LA and around the country. This is something that, clearly the founders were concerned about. There's been a lot of debate about how this should be used. So I'm not trying to diminish that. It may well be that the forces are used in an improper way, but we don't have any evidence of that right now. All we have is a document that says we have a federal facility under attack, or that violence has been, forced it to close down, and we want to protect it. That doesn't strike me as a glaring overuse on its face. Now, if what happens is what you're suggesting, that they do engage in law enforcement activities, then obviously we have another problem. But that's not even what the district court found. You couldn't find it. There's no deployment at this point.
Well, certainly. We're not talking about like the violations of the Posse Comitatus Act.
We do a little trolling. It's called we do a little trolling.
But what we have is from Newsom. We know
do a
that
little
this
trolling.
court
It's called we do
has
a little
role
trolling.
in evaluating the president's determinations. There is a direction that is this court's role. This is the case, though, that represents the outer limits of the president's authorities. We have, in the month leading up, not even the week, if we look at the entire month of September, the district court found there was one instance in the kind of the weeks leading up where protesters shined flashlights in the eyes of drivers.
If that's true, then I think we've got a problem, because I don't think that's what the record says. If the district court really said that's all that happened in September, then the district court's clearly erroneous. I didn't think the district court said that. I thought the district court actually detailed more than just one incident in September where flashlights were shined in the eyes.
Well, Your Honor, that's the record, though. Even if we go back to...
Well, we'll have to go into it, but I don't understand the record to be that for September. I understand it to have gone down, but not that there was one incident and that was it.
That's not us saying. There were certainly protests throughout the month of September, but they were, as I earlier mentioned, and the district court found, small, less than 30 people, largely sedate, generally peaceful. That's what was happening in September. So there was an incident on Labor Day on September 1st where there were increased protests. 125 people were involved in the activity. But what we have is the statement from FPS that they were not concerned with the group. That's at 46-1. This is the day when the guillotine was displayed.
Right.
But that's arguably protected political speech. There were 40 people who remained after the larger group left, and they did arrest a few. After that, you have September 2nd, completely uneventful. September 3rd, there was a drone flying. There was some altercations. Everything was managed. That's the consistency throughout the month of September. And there were occasions when there might be, a larger number of protesters, but they were generally calm and sedate. And any of the sporadic and kind of more minimal criminal activity was appropriately handled by law enforcement resources. And that's what's supposed to happen, because the situations that we're talking about, even the situations where it unfortunately could include an assault on a federal officer, that's a crime. That's a crime that was handled. They were arrested, and I understand that the U.S. Attorney's Office had 22, they're prosecuting 22 defendants. That's how this process is supposed to work. It's not that there is a protest, there is and then you just send in the military. This is protected speech. And for the most part, it is calm and sedate. And it
so
is
the drone.
something.
So the drone on, I guess this is the Wednesday. The suspect got violent and spit on agents. He was arrested and booked.
That's general criminal activity that's handled appropriately by law enforcement. On the 4th, you have 20 protesters, and then there's only 15 at 8:30. On the 5th, FPS said it was a small group with low energy, no calls for service. On the 6th, there was 50 to 60 active protesters, lots of noise. They were energized, no arrests. September 7th, 7 people, low energy. September 8th, 30 people. There were an altercation between protester and a counter protester, not against the facility. It continues, and I'm happy to go through the record.
No, this is helpful. We'll have to go through it. I mean, I don't think there's any question that it's gone down in September, but part of the problem there is it's gone down largely because of this influx of other forces, which is outside of the regular use of those FPS officials. So
does the record show us how many of the extra people remain in Portland, the FPS, and how many have been sent back to?
I don't know if you heard the question. I think it was, does it show? I mean, we know that up to 115 came. Do we know how many were there of the extra FPS? Maybe this is for the,
or something. Did you not hear?
Yeah, we're not hearing you very well. It's kind of getting muffled for some reason.
Well,
there you go.
Okay, I'm right by the microphone. Does the record show, the record is in front of us, how many of the FPS officers from outside?
We do a little trolling. It's called we do a little trolling.
Remain in Portland now, and how many have been sent back to somewhere else?
We do a little trolling. It's called we do a little
numbers, and much of the declarations don't have dates associated with them, so it is also very possible that those officers
we do a little trolling. It's called we
in
do a little
June,
trolling.
and they have all returned. We have a note within the last week before the president's announcement that there was a surge of officers.
We do a little trolling. It's called we do a little
there was
trolling.
no responsive protest activity, and so they went back to their respective offices. And then even after, I think that they may have plussed up their numbers in anticipation of the president's announcement. But then even then there was some increased protest activity, but it went back down. And
so the answer seems to be you don't know from that we can't know from this record. And I believe counsel on the other side said, well, they haven't all gone home, but I understood him to say, saying indirectly that some or many have gone somewhere else.
Certainly, a lot of them have gone. And what we also know from one of the declarations is that FPS, they respond to even nonviolent protests. This is their job. They respond to potential threats. And they would use those numbers of officers to go to any kind of that exercise of speech, just in case something becomes violent. So this is squarely within their area of responsibility. And I know we continue to talk about FPS, but we haven't even talked about any of the other federal officers that are at the president's disposal. We have a ton of law enforcement agencies under the president's control. There's referencing in their declarations to circumstances, again, that are outside of what happened in Oregon, or even if there was potentially a bomb threat. Well, we don't have anything that connects the bomb threat to these protesters. And if you do, you have significant law enforcement resources, ATF, FBI, that can respond to those potential threats. That's their job. That's what they do.
The problem that I have with this argument that I'm just trying to struggle with is, the president gets to direct his resources as he deems fit. And it just seems a little counterintuitive to me that the city of Portland can come in and say, no, you need to do it differently. Now, I understand there's a statute here and we're going to have to review that. But this goes to the level of deference that I think the president is entitled to in these circumstances. And it's not all driven Would you agree it's not all driven by what we see on the streets? It's also driven to some degree by what's going on behind the scenes. And you don't have a full view into that.
I acknowledge that there is certainly information behind the scenes, but we don't have that in this record. And we don't have the defendants coming forward and putting forth anything that shows that the sporadic and minimal instances of violence, criminal activity that was appropriately handled by law enforcement at Portland is part of a greater whole. I think the district court found that, the defendants did not present any evidence that the sporadic violence was part of an organized attempt to overthrow the government. And that's, I think, what they're asking this court to potentially look at when you're talking about, for example, the shooting in Dallas, that somehow increases the need.
Well, that goes to your rebellion, or that goes to their rebellion designation, but that doesn't necessarily go. I mean, you don't have to have that under prong 3, do you? For the enforcement of the laws.
Well, I'm sorry, I don't understand the.
Well, I mean, enforcement of the laws. You seem to say, well, there's no attempt to overthrow the government. And I mean, that's a fight within the context of whether there's a rebellion under subsection 2. But I don't know why that is relevant to subsection 3, which doesn't have anything to do with rebellion and is just the enforcement of the laws.
Well, I agree that the Dallas shooting shouldn't be the basis to send troops into Oregon. And if we're relying on that third prong, then it certainly, it doesn't make that more or less probable.
Can I add just, and maybe my colleagues have final questions too, but, and I don't want to focus on it, but I'm just perplexed. And I think Judge Beatty may have referenced this. So they reopened the building, they board the windows for protection. And what does the city of Portland do? They issue a zoning violation. Are you defending issuing a zoning violation, telling them to take off the boards that were put up to respond to protesters? Do you think that was maybe ill-advised?
Luckily, in this case, it's not something that the court needs to decide to determine whether or not the president's determination was within a colorable basis or within the range of honest judgment. But what we do know is that the circumstances at the time the president authorized the troops, whatever date that might be, they didn't raise to the level that was necessary under the statute. And we would ask that the stay be denied.
Any other questions by my colleagues?
No.
Thank you.
Thank you, Your Honor.
We'll have 3 minutes of rebuttal.
Thank you, Your Honors. I just have 3 quick points that I'd like to make. First, Judge Graber, going to your questions about the basis for the determination, we're not relying solely on the June 7th memo. My basic understanding is the June 7th memo was where the president sort of set out the framework and his understanding and interpretation that violence directed at ICE officers that seeks to impede their execution of the immigration laws is the sort of circumstance that can warrant activating the guard. And President then subsequently made a determination that those circumstances were satisfied in Portland. If you look at page A52 of our appendix, you'll see that's where the DHS request is. DHS said that the facility in Portland and the ICE officers and the FPS officers have come under coordinated assault by violent groups intent on obstructing lawful enforcement actions. These groups have sought to impede through violent protest, intimidation, and sabotage of federal operations. That was the information that was before the president when he made this determination in September. Second point I want to make is about the language of the statute talking about a present inability to execute the laws. Because of the violence that's ongoing and the risk of violence that's ongoing, there is a present impediment to the execution of the laws because the forces are tied down addressing that risk. We've discussed the FPS officers. It's not just the FPS officers, it's also ICE personnel. If you look at page A85.
Do you have an answer to Judge Graber's question about how many FPS, there were 115 that were there in July at least, and maybe longer. How many are there? How many were there in September of the additional?
I do not
Okay.
know the answer, and I do not believe the record speaks to that. The citation that the plaintiffs provide in their brief to say that some have gone home is document 4626. You'll have to take a look at it for yourself. My best recollection, I don't have that document at my fingertips, my best recollection is it referenced about 10 people going home. But it's not just the FPS officers. If you look at paragraph 16 of the Cantu Declaration, it says the situation has resulted in FPS having to rely almost exclusively on ICE special response teams for assistance in preventing the violent protesters from attacking immigration officers and the ICE facility. And he explains that their primary mission is to be out in the field, handling high-risk immigration enforcement operations. But they're now having to be diverted to protect the facility, becoming a drain on immigration enforcement as well. If you look at the Walmsley Declaration, paragraph 20, pages A77 to 78, it is to like effect. The final point that I want to make is, although we do think the judge was clearly wrong to circumscribe the inquiry to what was happening in September, I think the district court also did minimize the violence in September. I just want to highlight a couple of documents that are in the record. One is that our supplemental appendix A2 to A3.
Counsel, are you now withdrawing what you said earlier, which is that you are not challenging as clearly erroneous any of the specific factual findings that the district court did make as distinct from ignoring certain things?
I'm not challenging factual findings about what she said in terms of X event occurred on Y date. There may have been other events that occurred on other dates that she didn't address. That's not, I think, an issue for clearly erroneous review. But if you look at page SA2 to 3, this is on September 28th. This is one of the police reports. It starts out talking first about how a group of these agitators attacked 2 observers, breaking the driver's window and leaving one of them bleeding heavily from the face. And then it says there were 50 to 60 protesters outside of ICE at the time. Most of them were blocking the facility's driveway in anticipation.
I've read that document. I have a different question about it. Does that not post-date the final document on which you were relying as part of the call-up? And didn't that happen after September 28th? Is the memo from the secretary?
Right, and so that's that same day addressing.
Okay, is that the final document on which you rely? And I guess my question is, can you rely on any event that post-dates the mobilization to justify the pre-existing mobilization? In other words, let's say there's nothing that happens at all. This is a hypothetical. Nothing happens, but troops are mobilized, and 2 days later, there are terrible things that happen. Does that go back in time to justify, or does there have to be something at the time of the mobilization?
I certainly think this evidence is fair game because it shows...
That's not an answer to my question. Can you rely on later evidence to justify a prior authorization?
I think we can rely on later evidence to show that there was a colorable factual basis for the president's determination here, because it demonstrates the very kind of risk that can materialize at any time with this sort of violent crowd. But it's not just on the 28th. If you go back a week earlier on September 20th, this was at page A104 of our appendix. It says, another police report, FPS agents were busy tonight. There was a group of 50 at the facility. Again, once a marked car drives through, they will flip off, scream, and throw objects at the car, and in most cases run towards the car as if they are going to charge the car. FPS Will Turner called me throughout the night with info about black blockers assaulting people. I received a video from FPS about a report about a journalist who was assaulted by a black blocker with a large Sortor stick. To be clear, even if these folks were still at ICE or nearby, we would not be able to address the call or make an arrest with the resources that we have. This is hardly the peaceful and sedate crowd that plaintiffs tried to make it out to be. These are violent people, And if at any point we let down our guard, there is a serious risk of ongoing violence. And at some point, the president is entitled, when his subordinates are telling him, we are overstretched, this is unsustainable, the officers aren't available to do their jobs, they're not available to surge to other places where we face violence. The president is entitled to say enough is enough and bring in the National Guard to reinforce the regular forces. We would ask the court to grant a stay pending appeal as swiftly as possible.
Thank you. Thank you to both counsel for your arguments in the case. The case will be taken under advisement, and we'll respond as quickly as we're able. Case is now submitted.
All persons having business with the Honorable, the United States.
We do a little trolling. It's called we do a little trolling.
Circuit will now depart, for this court stands adjourned.
We do a little trolling. It's called we do a little trolling.
Welcome to the Deep Dive. We take complex source stacks, often polarized, and boil them down into the key insights for you. Today we're digging into a movement that's been around for decades, but has really hit the headlines recently. Anti-fascist action, often known now as Antifa. Our sources are, well, they're quite something. We've got everything from these really detailed, gritty accounts by activists in the UK back in the 80s and 90s, all the way up to current U.S. government documents, even executive orders trying to label the modern movement as domestic terrorists. So our job here is to unpack these clashing stories, look at the history, the structure, the controversies, and just lay out the different perspectives impartially for you.
Yeah, and the real puzzle, the core tension we're trying to get at is how does this kind of loosely connected social movement, I mean, people involved often say it's more an idea than an organization. How does that become the target of a major, executive level national security debate? So we'll trace it from its pretty organized and militant roots in Britain to the modern, much more decentralized form, and look at these really conflicting views on its tactics and its legal status.
Okay, let's start with that history then. Not in the U.S., but the U.K. blueprint. Anti-Fascist Action, AFA. Active mostly, 1985 to 2001?
That's right. And this militant anti-fascism wasn't new even then. It follows this tradition going back to the 1930s, like the famous Battle of Cable Street. AFA was definitely formed in that spirit, specifically to counter groups like the British National Party, the BNP, which were gaining ground.
And their approach was defined by, what was the phrase?
Physical and ideological opposition to fascism. That was their stated aim. And you have to understand, the groups they were up against, like the BNP, weren't just holding meetings. They were engaged in, violent campaigns against minorities, against working class groups.
Right, selling racist papers on the high street, attacking places like that left-wing bookshop in Liverpool. News from nowhere.
Exactly. It was direct physical intimidation, not just abstract politics.
And the sources suggest AFA was, pretty effective at that physical opposition, at least in certain areas. Liverpool's a key example, isn't it?
It really is. The BNP had been quite persistent there, despite local opposition. But then ASA stepped in. And there's this pretty striking quote in our sources, apparently from the Liverpool BNP itself, admitting they were, and this is the quote, driven underground by left-wing extremists in the mid-'80s.
Wow. So not just pushed back, but effectively shut down locally.
That was the goal. It was about physically preventing fascists from organizing and spreading their message in public spaces.
So how did they organize to achieve that? It sounds like more than just spontaneous reactions.
Oh, definitely. AFA set itself up as a militant united front, intentionally broad, bringing together mainly anarchists and Marxists like the group Red Action.
A united front.
Mm-hmm.
What held it together?
The core agreement was what they called a class perspective. The argument was basically that fascism's ultimate goal is to destroy working class power structures, unions, community groups, political parties. So from their viewpoint, only the working class had the fundamental interest and maybe the necessary strength to truly defeat it.
And they could mobilize that strength. The sources talk about some major actions.
Yeah, this was really their peak. They deliberately confronted groups like the National Front and the BNP at very symbolic, sensitive locations.
With the Remembrance Sunday events.
Exactly. At the Cenotaph in London or Clifford's Tower in York, a site with a heavy history of anti-Jewish violence, They went where fascist groups were trying to gain legitimacy.
These weren't peaceful protests necessarily.
Not always, no. They talk about actions that smash the Nazi music network Blood and Honor, essentially driving them off the streets around 1989. And then there was the Battle of Waterloo in 1992. That was huge. The sources say over 1,000 anti-fascists mobilized for that confrontation.
1,000 people. That's serious mobilization. They were clearly focused on controlling the streets.
Absolutely. It was about physically denying space to fascist organizations.
But did that single-minded focus on street confrontation eventually cause problems for AFA itself? Because the sources show this united front eventually just fell apart in the mid-90s.
It seems it did. There were internal conflicts, sure, maybe personality clashes, but the big split was strategic, a fundamental disagreement about the way forward.
Okay, what was the core issue?
Well, you had factions. Some, particularly anarchists, were very concerned about the organization itself, potential police infiltration. They had disagreements with groups like Searchlight Magazine, suspecting links to special branch, police intelligence.
Okay. But that wasn't the main split.
Yeah. The defining break, according to these accounts, was over electoral politics.
Ah, right, the IWCA, the Independent Working Class Association.
Exactly. After the BNP actually managed to get a councillor elected in 1993, some within AFA, particularly Red Action, started arguing that street fighting wasn't enough. They argued AFA needed to shift to build a political alternative, and they pushed for this new party, the IWCA.
And that didn't sit well with everyone.
Not at all. It completely alienated large parts of the AFA core. Many were anarchists, fundamentally opposed to electoral politics. Others argued that a united front specifically built for street action couldn't possibly endorse one specific political party without destroying the unity.
So the very thing that made them strong, that broad unity for direct action, was undermined by the move towards politics.
It seems that way. And there were other factors, too. The sources mention police tactics adapting.
Right.
Activists getting older, having families, maybe just burning out, and competition from other, possibly better-funded groups like the relaunched Anti-Nazi League.
So AFA, this organized, centralized model, it kind of faded away because that structure couldn't hold.
Yeah, it became unsustainable.
We do a little
Okay,
trolling.
so
It's
let's
called
bridge
we
the
do
gap
a
now.
little
We
trolling.
jump forward a couple of decades across the Atlantic to Antifa. How does the decline of the organized British AFA
We do a little
relate to
trolling.
this
It's called we
modern,
do a little
much more
trolling.
talked about, decentralized U.S. phenomenon? And the name itself, where's that from?
Well, the name Antifa is actually much older than the British AFA. It comes from German, antifascistische Action, anti-fascist action. It was first used by the German Communist Party back in 1932, specifically to counter the Nazis.
1932. Okay, so the term itself has deep roots in European anti-fascism.
Definitely. And that history leads us to the really crucial difference today. Modern Antifa isn't an organization like the British AFA was. It's generally defined as an umbrella term. It describes a far-left anti-fascist political movement, but it's characterized as a loose affiliation of local activists. Critically, there's no designated leadership.
No central command, no membership list.
Exactly. It's more of an ideology, a set of shared tactics and goals rather than a formal group. And that makes it fundamentally different and much harder to pin down or control.
Which brings us to the symbolism, that iconic logo, the two flags. You see it everywhere now.
Right. The two flags typically overlapping. One red for socialism or communism and one black for anarchism. It visually represents that umbrella concept, different left-wing tendencies united under the banner of anti-fascism.
Okay, now this is where it gets, let's say, contentious, especially in the media. The tactics. Let's talk about the black bloc. What is that, strategically?
The black bloc isn't a group, it's a tactic. Activists dress entirely in black, cover their faces with masks, bandanas, helmets sometimes. The purpose is pretty straightforward. Anonymity. It makes it harder for law enforcement to identify individuals, especially if property destruction or physical confrontation occurs.
Like during the Trump inauguration protests in D.C., January 2017.
That's a prominent example, yes. It also creates this visual image of a unified, somewhat intimidating force.
And beyond the streets, there are digital tactics too, like doxing.
Correct. Doxing involves researching and publicly exposing the private information of opponents' names, addresses, employers. The aim is often to intimidate them, cause social or professional harm, and neutralize their activities. We've seen it used against alleged white supremacists on campuses, for instance.
And on a larger scale, I remember something about ICE employees.
Yes, in 2018, an account linked to Antifa activists reportedly published personal details of over 1,500 Immigration and Customs Enforcement, or ICE, employees. The sources say this led to threats and harassment against federal agents. For some anarchist extremists within the broader movement, that level of disruption is seen as success. They might even measure it against the chaos and property damage during the 1999 WTO protests in Seattle. That's sometimes held up as a benchmark.
A sort of Seattle standard for disruption.
Kind of, yeah, for a certain element.
Okay, before we get into the whole terrorism designation debate, there's a weird wrinkle in the sources groups trying to sort of hijack this imagery.
Yes. The National Anarchists. It's important to mention them, though they seem quite fringe. Groups like BANA, Bay Area National Anarchists, apparently practice what's called entryism. They try to infiltrate or mimic left-wing anarchist movements, but their ideology is completely different. It's actually white nationalism, racial separatism. They talk about creating whites-only enclaves, national autonomous zones, they call them.
So they use the language of anarchism and environmentalism to mask essentially white supremacist goals.
Exactly. It's an attempt to co-opt the aesthetic and language of the far left for far right aims. A very strange hybrid.
Okay, so keeping that complexity in mind, let's turn to the big contemporary fight. The push in the U.S. to designate Antifa as a domestic terrorist organization. Given everything we said about it being a loose affiliation and ideology, how did that even become a serious proposal?
Well, the political pressure built hugely, especially after the widespread protests and riots in 2020. High-level U.S. officials, and eventually an executive order signed in September 2025, started framing Antifa very differently. The language used describes it as a militarist anarchist enterprise. It explicitly accuses the movement of calling for the overthrow of the U.S. government.
Strong words. What specific actions did they cite?
The IA-2 mentions using violence, obstructing federal law, specifically citing violent clashes with ICE officers, and accuses them of actively recruiting and training people. The overall claim is that they aim to achieve their goals through coercion and intimidation, so painting a picture of a coordinated violent threat.
That sounds pretty definitive. But what happens when you apply legal scrutiny? Can the U.S. government actually designate a domestic group like this?
And that's the crux of the legal debate. The short answer is currently no. U.S. law has mechanisms for designating foreign terrorist organizations like Al-Qaeda or ISIS, but there's no analogous mechanism for domestic groups, primarily because of the First Amendment. Designating a domestic group based largely on ideology, especially one without a clear structure or leadership, raises huge free speech and association concerns. Former senior Justice Department officials warned this would be legally very problematic. You'd essentially be outlawing a political viewpoint.
Okay, so legally tricky. What about the intelligence picture? Was Antifa actually responsible for the scale of violence attributed to it in 2020?
That's also heavily disputed in the sources. For instance, an FBI Washington field office report from June 2020 apparently stated they had no intelligence indicating Antifa involvement in certain specific violent incidents during the DC protests at that time.
No intelligence connecting them. But who was involved then?
Well, intriguingly, the same intelligence reports warned about far-right extremists. They specifically mentioned calls from far-right provocateurs urging attacks on federal agents and even using automatic weapons against protesters.
So the intelligence picture was actually pointing more towards far-right instigation in some cases.
It suggests the situation was, at the very least, much more complex than just blaming one group. Attribution of violence in chaotic situations is notoriously difficult and potentially politicized.
And this idea of the state trying to define and control or dismantle an anti-fascist movement, you're saying this isn't entirely new?
Not at all. We can connect this to historical examples of states using anti-fascism for their own purposes.
Like East Germany, the GDR, during the Cold War.
Precisely. In the GDR, anti-fascism wasn't just an organic movement, it became a core part of the state's official identity. It was almost a state religion. They used it as a powerful propaganda tool. It served to legitimize the socialist state, portraying West Germany as the inheritor of fascism.
And by doing that, they could sort of excuse or ignore any Nazi past among their own population?
Largely, yes. It helped create a narrative that fascism was purely a Western capitalist problem. And crucially, it was used to identify and target internal dissenters or external enemies as fascists or fascist collaborators.
So anti-fascism became a tool of state control and legitimacy.
A very effective one, for a time.
And is that how activists today view this push for a terrorism designation? Is the state trying to co-opt or weaponize the label?
That's exactly the argument many activists make, yes. They see the designation attempt as a political tool, a way for the government to demonize adversaries. Some argue that, from the state's perspective, anti-fascists who engage in direct action were always illegal because they challenged state authority and property norms.
Regardless of whether the police were perceived as dealing with the far-right threat effectively.
Right. They might say they're stepping in precisely because the state isn't stopping fascism,
No.
but that challenging role itself makes them a target for state repression, regardless of the label used. They see it as a tactic to neutralize political opposition.
Okay, so let's try to synthesize this for you, the listener. We've tracked this trajectory from the organized, street-focused, militant anti-fascism of the British AFA, which had measurable success in physically disrupting groups like the BNP, to the modern, much looser, ideologically defined Antifa movement, primarily in the US, which is now embroiled in this high-stakes political battle over its very definition and legality. And that distinction between AFA, the organization, and Antifa, the ideology or movement, seems absolutely critical to understanding the current situation, doesn't it?
It really is. And the synthesis, I think, points to this recurring theme. Anti-fascism, whether it's a tightly organized group or a diffuse ideology, consistently gets framed by its opponents as a dangerous threat. Those opponents might be the far-right groups it directly confronts, or they might be state actors who see it as a challenge to their authority or social order. So the fight often becomes less about the actual threat level posed by, say, scattered groups of activists, and more about who holds the power to define the enemy and control political conflict.
Right. The power to label is immense. Which brings us to our final thought for you to consider. Something to mull over. We talked about East Germany using anti-fascism as a state tool, but let's go even further back and maybe stranger. There's a declassified CIA report from 1952. It mentions something called the Central Antifa School at Ogre.
Ogre, in what was then the Latvian Soviet Socialist Republic. According to this report, this wasn't a grassroots thing at all. It was a Soviet facility that allegedly trained around 2,000 people, including former prisoners of war, specifically for subversive actions targeting Western countries. The program was apparently called a policy of persuasion.
Wow. A state-run school training Antifa agents for subversion in the West, back in the 50s.
If the report is accurate, yes. So the
Yeah.
provocative question this leaves us with is this. Across different times and places, have the label anti-fascism served these dual, almost contradictory purposes? Has it been both a genuine bottom-up tool of resistance against real fascist threats and simultaneously a highly organized, state-sponsored instrument used for espionage, political warfare, and propaganda?
That duality, grassroots resistance versus state tool, that really adds another layer of complexity to understanding this whole phenomenon.
We do a little trolling. It's
Something
called
to
We
think
Do a
about.
Little Trolling. We do a little trolling. It's called We Do a Little Trolling. We do a little trolling. It's called We Do a Little Trolling.
Welcome back to the Deep Dive. Today we're tackling a really charged
We do a little
topic.
trolling. It's
We
called
move
We Do a
past the
Little
headlines, the usual sound bites.
Yeah, we need to. We're aiming for a meticulous, critical investigation.
Our mission today is to trace the history, the tactics, and, crucially, the core ideology of the Antifa movement.
And it's absolutely vital we approach this critically. Because when you actually dig into the source material, and we've got quite a stack here,
We really do.
you know, everything from declassified Cold War intel, historical docs on European extremism, right up to detailed investigative reports on modern paramilitary groups, it becomes clear.
What becomes clear?
Well, that this story is much older and frankly far more complex than just, you know, a reaction to current events.
Exactly. So the aim here isn't really to debate whether being anti-fascist is good or bad. That's not the point.
No, it's about investigation.
Right. We're investigating what these sources consistently seem to show. A movement that's defined by political extremism, by coordinated violence, and a pretty long-standing pattern of subversion. We're looking at the movement itself, not just the label.
And just to give you a taste of the kind of depth we're talking about today, we're going to be looking closely at, for instance, a 1952 CIA report.
1952.
Yeah, detailing a specific Soviet-run Central Antifa school, its purpose, subversion.
Wow.
And we're going to trace that lineage, that connection, directly through to the modern day, specifically the U.S. government's designation in September 2025 of Antifa as a domestic terrorist organization.
So this critical framing is really essential for the whole deep dive.
Yeah.
We're tracing a history that's consistently defined by confrontation.
That's the thread.
From its ideological roots in, interwar European extremism,
Yeah.
then through decades of militant street fighting in the UK.
Yeah, that's a key link.
And finally, how it shows up today. This sort of anonymous, chaos-focused force operating on American streets. Okay, let's unpack this history then. Starting with the name itself, Antifa. It's short for anti-fascistic action.
Nerman, yeah.
And its birth wasn't accidental, it was explicitly political. Right out of a period of really intense ideological street battles.
You have to go back to the Weimar Republic, specifically 1932. This was a time when the political center was just crumbling.
Total chaos.
Pretty much. The streets were dominated by highly organized political fighting groups. And Antifa, the term, was formally proclaimed that year by the Communist Party of Germany, the KPD.
The KPD, yeah.
And what the sources stress, it wasn't like a single fixed organization back then. It was more called to a collective movement.
Right, but the KPD context is vital here. These weren't just like local activists.
No, absolutely not. They were militant Bolsheviks. They were operating under the direct, very strict influence of Moscow, the Comintern.
And following that Soviet line meant,
Yeah.
well, it meant their priorities were sometimes skewed, right?
Yeah, totally skewed. The KPD often saw the democratic socialists, the moderate parts of the Weimar government, who they actually called social fascists, as their biggest, most immediate threat.
More dangerous than the actual Nazis, in their view.
Often, yes. They prioritized fighting the democratic leftover, fighting the rising Nazi party. It seems unbelievable now, but that was the Moscow line.
And the symbolism they chose, that iconic logo with the two flags, that tells its own story, doesn't it? About the kind of alliance they wanted.
It does. The logo, designed by communist artists, shows two flags, red and black. You often see them tilted.
Red 4.
Socialism, communism, the KPD. And the black flag represents anarchism.
So it was meant to signify this united front of the far left revolutionary ideologies.
Exactly. A united front against the rise of National Socialism. At least that was the idea.
Okay, but here's where it gets, well, deeply ironic and tragic looking back at German history.
Yeah.
The sources point out that this escalating far-left extremism, defined by constant street fighting, clashing with the Nazi street fighters, the SA.
The Sturmabteilung.
Right. That violence actually, coincidentally, helped the Nazis. How did that work?
Well, fundamentally, it just added to the relentless chaos. The constant violence, street battles, property damage, assassination attempts, it wore people down.
And undermined the government.
Exactly. It further delegitimized the political center, the democratic Weimar government. They looked weak, incapable of keeping order.
Trapped between two violent extremes.
Precisely. And for many ordinary Germans, just exhausted by the turmoil, the Nazis, with their promise of strong, decisive, singular authority, well, they started to look more appealing.
So the far-left extremism, ironically, fueled the conditions that helped the far-right rise.
It contributed significantly to the instability. That's what the historical analysis suggests. Hashtag tag 2.2. Antifa as a tool of the communist state.
Okay, so the story of anti-fascistic action doesn't just stop when Nazi Germany is defeated.
Not at all. After World War II, the whole concept, the idea of anti-fascism, gets co-opted. It gets functionalized by the Soviet sphere.
Functionalized? How so?
In a really cynical state-sponsored way. This is where Antifa shifts, from street politics towards statecraft, propaganda, even intelligence operations.
Right. Particularly in East Germany, the GDR.
Yes, absolutely. In the GDR, anti-fascism essentially became the state religion. It was baked into the national identity during the Cold War.
A state religion. That's a strong term. How did that manifest? What did they actually do with it?
It was this all-encompassing narrative. It served really three critical functions for the communist regime there.
Okay, what were they?
First, it legitimized the new state, the communist state, which wasn't democratic. They claimed they were the true historical heirs of the anti-fascist struggle.
So it gave them a kind of moral authority.
Supposedly. Second, and this is really crucial, it was used to basically exculpate the German population.
Exculpate? Like absolve them of guilt?
Pretty much. By insisting the regime itself was fundamentally anti-fascist, the vast majority of people could sort of distance themselves from collective responsibility for the Nazi era and just integrate into the new socialist state.
Wow. So the past just gets neatly repackaged.
Exactly. And third, strategically, it was used to externalize fascism. Fascism became something that belonged only to West Germany.
The enemy across the border.
Precisely. The communist state used relentless propaganda, branding the Western allies, the Americans, and their West German system as the worthy successors of the fascists.
So the entire history of National Socialism gets twisted.
Completely functionalized, made subservient to the immediate Cold War strategic interests of the Soviet Union. This whole cultural memory was deliberately constructed to integrate people and justify the regime's absolute power.
And this wasn't just about propaganda and history lessons. We have actual intelligence documents showing it went much deeper.
We do. This is where that CIA report comes in again.
Right, the 1952 report.
Yes, February 1952. It's direct evidence of state-sponsored subversion, the existence of this central Antifa school at Ogre.
Ogre, where's that?
In the Latvian Soviet Socialist Republic, part of the USSR back then.
A Soviet training camp specifically for Antifa action. Okay, let's dig into that. The personnel, the curriculum.
Yeah.
What does the report say?
Well, the report details the command structure of this place. Ogre Central Training Camp number 2040. The headquarters staff included some pretty high-ranking intelligence figures.
I'll go.
An MVD officer, that's Soviet military intelligence, a Colonel Stabin, and also a KPD officer, a Captain Pinkelgas.
So Soviet intelligence and the German Communist Party running it together.
Jointly. Which really signals how important and how subversive this operation was considered.
Okay, and what were they teaching there? The report mentions about 400 students, mostly ex-POWs.
Yes, and the training wasn't just, political theory. It was specifically in subversive actions. They even had a name for it. The policy of permutation.
Policy of permutation. What did that actually involve on the ground? What kind of subversive actions?
Permutation was basically the playbook for deep, long-term communist subversion inside Western democracies. This wasn't training people how to protest on the streets.
No. What then?
It was training for sabotage, for infiltration. Graduates were assigned special missions back into the western zones of Germany.
Special missions like?
Things like practical training on how to live covertly, how to be a saboteur, how to identify and damage critical infrastructure.
Wow.
And crucially, how to influence industrial workers, how to get them to participate in mass strikes, disruptive political demonstrations, using that unrest for political gain.
So these weren't activists in the way we might think today. These Antifa activists, trained by the Soviets, were essentially intelligence operatives.
That's what the evidence points to. Tasked with destabilizing civil society in the West, advancing Bolshevik goals, and using organized political disruption almost as cover.
That really does rewrite the popular history, doesn't it?
It certainly confirms that from that post-war period onwards, the Antifa label was directly tied to state-sponsored programs. Programs designed to sow chaos and subvert liberal democracies from the inside out.
Okay, so while the Soviets were busy co-opting this Antifa idea for state purposes, the original spirit, that sort of grassroots militant action, the physical confrontation part,
Yeah.
they didn't die out.
No, it reemerged quite strongly, actually, but somewhere else. Half a continent away.
We need to shift focus now to the UK.
We do a little
to the
trolling.
tradition
It's
of what's
called we do a little
physical
trolling.
force anti-fascism.
Yeah, and the key group there is Anti-Fascist Action, or AFA. They formed in 1985.
And the UK
We do a little
AFA
trolling.
seems
It's
to
called
provide
we do a
a
little
really
trolling.
direct tactical blueprint for what we see later in the US, doesn't it?
Absolutely. They were very explicit about their mission, their own words, physical and ideological opposition to fascism. They basically formalized the doctrine that revolutionary politics needs violence.
Needs it for defense or
Both for defense and, more importantly, to seize the initiative, to go on the offensive.
They actually relaunched in 1989 as a sort of militant united front, didn't they? Targeting the working class specifically.
Yes, and emphasizing that the whole system, not just fascism, but the entire system, needed to be smashed. That was the language used. To stop fascism getting any foothold, it was always a radical anti-systemic vision from the start.
And their methods, well, even according to their own accounts, they were all about confrontation. Relentless confrontation.
Which often spilled over into outright criminality. The sources highlight the Liverpool AFA chapter as a prime example.
What did they do in Liverpool?
They were apparently quite successful, tactically speaking, in smashing into the ground again, their words, any attempts by the British National Party, the BNP, to hold public meetings or marches, basically making it physically impossible for them to organize publicly.
But the violence wasn't always just targeted at the BNP, was it? The sources mentioned things got messy.
Yeah, that's a crucial point. The violence became indiscriminate sometimes, or at least strategically confusing. The Liverpool sources are quite specific about this.
What do they say?
They describe a campaign of violence against targets that were not fascist, including, for example, a left-wing bookshop called News from Nowhere.
A left-wing bookshop.
Right.
Run by feminists.
Yes, run by a feminist collective. They suffered smashed windows in daylight attacks, even attempted arson.
Why would AFA attack a left-wing bookshop?
Well, that's the chilling part. The sources note that sometimes these attacks on non-fascist targets were actually claimed by the fascists themselves.
To sow confusion.
Exactly, to create more discord, to try and pin the blame elsewhere. It shows the kind of environment they fostered.
So an environment so dominated by physical force and criminality that the lines just blurred, and the main outcome was just destabilization.
Yeah.
Making any kind of organized politics difficult, regardless of ideology.
It seems that way. It became this inevitable war of attrition, but this total commitment to a strategy based purely on confrontation, it eventually led to its own problems.
Right, you mentioned ideological bankruptcy, decline. This happened in the mid-90s.
Yeah, the united front that AFA had built started to fracture pretty badly.
What caused the split? It sounds like it fell apart precisely when they tried to move beyond just street fighting.
That's largely it. The internal schism was fundamentally about political direction. There was a strong Marxist element, particularly a faction called Red Action.
Right.
Around 1995, they pushed hard for AFA to shift towards becoming a formal political party. They wanted to found something called the Independent Working Class Association, the IWCA.
Trying to get into electoral politics.
Right. And that attempt to engage with the system, with elections, was basically ideological poison for large parts of the movement.
What poison?
Because you had the anarchists, their whole philosophy is built on rejecting electoralism, rejecting the state structure entirely.
So joining the system was fundamentally against their core beliefs.
Absolutely. They were disgusted by it. The movement was built on this anarchist, anti-state foundation of pure physical opposition. Trying to become a political party directly contradicted that.
Leading to, what, mass defections?
Mass defections, apathy, internal fighting, the whole thing just crumbled.
That's a really key insight, especially for understanding the movement later on.
Right.
It was geared purely for fighting.
Right.
And it basically atrophied when its main opponent, the BNP, cleverly shifted their strategy away from street fights towards trying to win elections.
Exactly. AFA's whole reason for being, their raison d'etre, kind of evaporated when the fight moved from the streets to the ballot box.
Were there other factors in their decline?
Yeah, a few things. The police got better at understanding and countering AFA's tactics. There was also competition from other, sometimes better-funded anti-fascist groups.
And just the sheer exhaustion.
Definitely. The heavy toll of attrition, constant arrests, serious injuries, the internal burnout that comes from trying to sustain a militant movement based purely on violence.
So the failure of the UK AFA really demonstrates something important, doesn't it?
I think so. It shows that a movement based only on confrontation without a positive political vision to build towards is inherently unstable. It's probably doomed to either decline or transform into something else entirely.
Okay, so that tradition of militant physical force anti-fascism, it didn't just vanish when the UK AFA declined.
No, it seems to have just sort of metastasized. It crossed the Atlantic, bringing that doctrine of confrontation directly into the American political scene.
And we can actually trace that line quite directly, can't we? From the UK AFA model, their networks.
Yeah, like the Northern network they had.
Yeah.
You can trace that lineage to the American experience. Many of the younger anarchists in the U.S. who follow this specific methodology are part of or came out of the Anti-Racist Action Network, ARA.
ARA. And the sources we looked at characterize ARA not just as, a community defense group reacting to things.
No, the framing in the investigative reports is different. They describe ARA as a national coalition of Antifa groups. And they call them the originators of organized, violent, left-wing street gangs in America.
Street gangs, that's strong language.
It is, but that framing is consistent. ARA and the groups that came after it explicitly confront neo-Nazis and racist skinheads on the street.
Which inevitably leads to violence.
It leads to predictable violence, yes. Their primary purpose, following that AFA doctrine we talked about, is physical confrontation. This pre-existing network essentially built the infrastructure for organized militant action here in the U.S.
An infrastructure that could then be activated when broader political situations, created opportunities for it.
Exactly. The foundation was already there.
Now, we really need to critically examine the narrative around Antifa's roots in the U.S. because you often hear attempts to link the movement to broader, maybe more legitimate protests.
Right. People trying to sanitize the history a bit.
But when you look at the internal documents, the analysis by the extremists themselves, they hold up a completely different event as their benchmark for success.
They do. And it's a 1999 World Trade Organization conference in Seattle, the WTO riots.
1999, why Seattle?
For the current generation of American anarchist extremists, the sheer level of rioting and disruption that happened around those WTO meetings, that is considered the gold standard. It was seen as a huge tactical victory.
A victory for chaos, basically.
Essentially, yes. And the consequences were massive. Millions upon millions of dollars in property damage, huge economic losses for the city.
And injuries, too.
Oh, yeah. Documented injuries to hundreds of law enforcement officers and bystanders caught in the middle, too.
And the key point here, strategically, was the chaos itself. Right. The sources mention that the number of people actually engaged in the violence and destruction, it was relatively small.
A very small fraction of the total number of protesters, maybe only a few hundred people at the absolute maximum, were involved in really violent stuff.
But they had an outsized impact.
Hugely outsized.
Yeah.
And that was seen as the strategic success that the movement internalized because the police response was so overwhelmed, so completely inadequate.
They ended up using tear gas indiscriminately.
Right, which affected everyone and just added to the chaos. So this small number of violent agitators managed to achieve maximum disruption. They basically shut down large parts of the city, damaged
We do a little
Seattle's
trolling.
reputation,
It's called
and
we do a
created
little
public
trolling.
chaos far beyond what their numbers would suggest.
So this event effectively proved to anarchist extremists that creating widespread chaos, committing crimes, generating public disorder, it's a highly successful tactic.
Yes, successful for achieving their political aims specifically, demonstrating the failure of the existing system, the state, to maintain basic order.
It gave them proof of concept. Calculated disruption works, even with a small, dedicated core.
Exactly. It became the benchmark for planning future actions. The thinking became, if we could cause that much systemic failure with just a few hundred people back in '99, imagine what we could achieve in a major city during, say, a summer of widespread unrest.
It set the template. Okay, so if the WTO riots set the standard for what success looks like, then the Black Bloc is probably the defining tactical method for the modern U.S. movement.
Definitely. It's all about anonymity and planned intimidation.
How does it work? Why the black clothing, the masks?
Well, the Black Bloc tactic is explicitly designed to conceal their identities. Everyone wears matching dark clothing, masks, helmets, anything to hide their face.
And the purpose is?
It's really twofold. First, it provides tactical anonymity. It makes it incredibly difficult for law enforcement to identify specific individuals who are committing acts of violence or property damage.
Safety in the crowd, basically.
And second, it creates this visual effect, a uniform, de-individualized mass. It looks far more intimidating, far more cohesive than just a random group of people. It projects strength and threat.
And the sources are pretty clear that these confrontations involving black blocs aren't usually spontaneous. They're often planned, almost militarized events.
Yeah, the 2017 DC inauguration protests are a perfect example documented in the reports. You had a black bloc, maybe 200 or more people.
Right.
They formed a specific line. They initiated a countdown, and then they charged a police line that was vastly outnumbered fewer than 24 officers.
Charging the police line.
Yes. And they weren't just, pushing. They were armed. The reports mention hammers, crowbars, wooden sticks, and other weapons.
So that's not defense. That's a calculated attempt to overwhelm law enforcement through organized, armed confrontation.
It certainly appears that way from the documentation.
Furthermore, the violence isn't just directed at police or property. It seems to be politically targeted too, used to silence opposition, not just clash with, say, the far right.
The documentation on this is quite clear, yes. This isn't random street brawling. It's often specific ideological targeting.
Could you give some examples from the sources?
Sure. There's the well-known case of the conservative journalist Andy Ngo in Portland, June 2019.
Right, I remember that.
He was physically attacked, quite severely, while covering demonstrations. He ended up hospitalized. That looks like a targeted attack on media perceived as hostile to the movement.
Silencing critics.
Potentially. Then there's Louisville, September 2020. Sources document individuals distributing riot gear, shields, masks, even a sign with an Antifa symbol out of a moving truck.
Handing out equipment.
Yes, hours before riots erupted that same day, which unfortunately resulted in 2 police officers being shot. This suggests premeditation, coordination, and supplying equipment for violent action.
In Berkeley, There were incidents there, too.
Berkeley, in 2017, both February and August, defined by black-clad agitators causing, estimates say, around $100,000 in property damage, and physically assaulting multiple people, including, the reports specifically note, at least one person targeted purely because of his perceived conservative political beliefs.
So direct political targeting.
It appears so. And the intimidation tactics go beyond just physical street confrontations. There's the whole digital side, too.
You mean doxing?
Exactly. Doxing is a primary psychological weapon for them. In June 2018, there was an Antifa-linked Twitter account.
Yeah.
It publicly posted the names and home addresses of over 1,500 immigration and customs enforcement employees, ICE agents.
1,500. Their home addresses.
Yes. And the explicit intent, which led to widespread harassment of those individuals and their families, was clearly to generate terror, fear, and disruption.
Targeting government agents, law enforcement, people representing the state.
Right. The goal seems to be to make the personal cost of working for the state, of enforcing laws they oppose, just too high, to intimidate people out of doing their jobs.
Okay, so given this pattern we've discussed, organized, politically motivated, violence, intimidation, targeting, we have to look at the most significant response from the state.
Which was?
The U.S. government's designation of Antifa as a domestic terrorist organization. That happened in September 2025.
Right. Now, that designation was controversial, particularly in how it was announced.
Via executive order in Truth Social, wasn't it?
Yes, which highlighted the political aspect. But the justification itself, the reasoning provided by the Trump administration, gives the strongest official assessment of how the government
is a legend.
And how did they frame it? What was the core justification?
They defined Antifa quite starkly as a militarist, anarchist enterprise, one that explicitly calls for the overthrow of the United States government, law enforcement authorities, and our system of law.
So focusing squarely on the anti-state, anti-system goals. But how did they connect Antifa's actions to the legal definition of domestic terrorism?
Well, they stress that the movement's coordinated violence, the intimidation tactics, the obstruction efforts, that these align specifically with the federal definition.
Which is?
Activities occurring primarily within the U.S. that involve acts dangerous to human life, carried out with the intent to intimidate or coerce a civilian population, influence government policy by intimidation or coercion, or affect government conduct by mass destruction, assassination, or kidnapping.
So they argued the violence wasn't random, it had a political purpose.
Exactly. The justification detailed what they saw as a systematic use of illegal means to organize and execute a campaign of violence across the country, citing organized riots, armed standoffs with federal officers, violent assaults on police. The aim was to demonstrate that political motivation behind the violence.
But as you said, the legal side was tricky. The U.S. legal system seemed to struggle with this. Why exactly is there currently no legal basis to formally designate a domestic group as terrorist, unlike foreign ones?
It really comes down to the First Amendment, freedom of speech, freedom of association.
How so?
Well, the government can designate foreign terrorist organizations, FTOs, without running into U.S. constitutional issues. But designating a domestic group that raises huge concerns about potentially criminalizing political speech or association.
So you could punish the actions, but not label the group itself.
That's the tension. Former senior Justice Department officials pointed this out. Any formal designation of a domestic group would raise significant First Amendment concerns. The government can prosecute the acts of domestic terrorism using existing criminal laws, arson, assault, conspiracy, etc. But formally branding a whole political group or idea as inherently terrorist is a much bigger, constitutionally fraught step.
Which is why the declaration came via executive order and social media, not through established legal channels for designating terrorist organizations.
Precisely. It functioned more as a political statement about the perceived nature and severity of the threat, acknowledging the legal hurdles to actually designating the organization itself in the same way FTOs are designated.
It signaled intent, regardless of the immediate legal mechanism.
Right. And interestingly, how did the anarchist sources themselves react to this? How did they interpret this move by the state?
Well, predictably, they saw it as a calculated political weapon.
A distraction.
Yeah, they called it a distraction piece. Something designed to demonize political opponents, rally conservative support. Their argument was that this designation was just a pretext.
Pretext for what?
To legitimize a maximum force response. Not just against the Black Bloc activists engaged in violence, but against all dissenting elements, all anarchists, anyone opposing the state. Their view is essentially, the state always saw us as a terrorist anyway. This just makes it official and justifies cracking down harder. Hashtag 4.2. Critiquing the media narrative. Okay, the public perception of Antifa has been, well, all over the place. Massively contentious. We really need to spend some time dissecting the media narrative around the group, especially the years leading up to that 2025 designation.
Yeah, the media's role in shaping how people understood Antifa is absolutely central to the whole story, and frankly, central to the confusion.
How so?
Well, for years, particularly, from maybe 2017 onwards, many outlets, especially on the political left, tended to downplay the movement.
Downplay the violence.
Downplay the violence, downplay the organization. You heard rhetoric claiming that warnings about Antifa were greatly exaggerated, or the famous line that it's just an idea, not really a group.
Which helped portray them as what? Quirky idealists. A fringe nuisance.
Something like that. It minimized the perception of threat.
But the sources we've looked at, the investigative reports, they paint a different picture. They confirm that while Antifa isn't some monolithic, centrally controlled organization with membership cards.
Right. It's not like that.
It's definitely more than just an idea. It's described as a loose affiliation of local activist groups, right? Militant groups scattered across the country.
Who adheres to a shared tactical doctrine, that black bloc approach we discussed, and share a common ideological goal, which is fundamentally anti-state action.
So it's organized, just not hierarchical in a traditional sense.
Exactly. And the difficulty in pinning down their true organizational scope, that's highlighted even in conflicting intelligence reports.
Oh, so?
Well, you have things like that internal FBI memo from June 2020, which found no intelligence indicating Antifa involvement in certain specific protests that summer.
And that gets cited a lot by people saying the threat is overblown.
It does, but then that conflicts directly with the on-the-ground reality reported by police during major unrest.
Like in Seattle.
It's like in Seattle, Portland, other places, where police estimates consistently put the number of people engaged in coordinated property, crime, arson, assaults on officers, the black bloc tactics in the few hundred range during specific events.
So why the discrepancy? Why couldn't the FBI always confirm involvement?
It points to the core challenge for intelligence agencies. The structure is decentralized. And crucially, there's the pervasive anonymity of the black bloc.
Masks, same clothes, burner phones.
Exactly. When the perpetrators deliberately conceal their identities and use encrypted or burner communications, proving a direct organizational structure or top-down coordination for specific criminal acts becomes incredibly difficult for investigators.
They leverage that low visibility, that anonymity.
It's key to their operational security. It helps them maintain distance from formal prosecution as an organization.
So the media's failure, perhaps, to critically assess
We do a little
all the available
trolling. It's
source
called we
material,
do a little
including police
trolling.
reports and historical context, that often contributed to the confusion, painting the violence as spontaneous, localized reactions.
It
We
seems
do a little
that way.
trolling.
Instead
It's
of seeing
called
it
we
as
do a
the
little
culmination of this longer militant tradition we've traced.
And that strategic ambiguity, being just an idea when it's convenient, but then appearing as a highly coordinated, almost military-style bloc when necessary.
That's arguably the core tactical genius, if you want to call it that, of the modern movement. It makes them very hard to define and counter.
Which brings us back really to the fundamental question we started with. Is that anti-fascist label? Is it just a cover, a strategic misnomer for something much more radical, something fundamentally anti-Western?
Based on the evidence, the tactics, the targets, the historical lineage, the argument that the label is primarily strategic seems very strong.
Because the underlying ideology isn't just about stopping fascists.
No, it's rooted in anarchist extremism, and that philosophy explicitly calls for the dismantling of the existing social order.
Through what I mean?
Through anti-capitalism, anti-globalism, even a kind of radical anti-urbanization in some strains. It's about overthrowing the whole system.
And their choice of targets seems to bear that out, doesn't it? They don't only go after far-right groups or rallies.
Not at all. They systematically target what they see as symbols of Western civilization, things they perceive as the root causes of society's problems.
Rather than just focusing on specific political opponents.
Right. The focus is broader. It's systemic destabilization. Look at the targets listed in the reports. Financial corporations, government buildings, multinational companies, police stations, law enforcement officers themselves.
Things representing capitalism, the state, globalization.
Exactly. The documented intent often seems to be damaging and vandalizing property, rioting, violently disrupting the functioning of the existing capitalist state structure. The method is consistent. create chaos, to destabilize the system, and silence political opposition of all kinds.
And if we look at the campaigns mentioned in some of the more recent sources, like Antifa International, that broadens the picture even more, doesn't it?
It really does. It shows that fighting the local far right is often secondary now to a much wider radical agenda.
What kind of campaigns are they involved in internationally?
Well, the sources mention transnational campaigns like Defend Refugees, Stop the Far Right. That's still there, but also, very tellingly, things like a week of action against Israel's F-35 genocide jets.
Okay, so that clearly goes far beyond just local street fighting against neo-Nazis.
Absolutely. It shows the movement has expanded its focus. It embraces a whole range of radical, anti-Western, anti-globalist causes.
So when you put it all together, the consistent use of violence, the doxing, the anonymity, combined with these really broad ideological targets.
Yeah, it strongly suggests that the movement's true goal isn't merely stopping fascism in the traditional sense. It's about advancing a radical anarchist agenda.
An agenda achieved by destabilizing civil society and silencing all political opposition, using physical force and intimidation as the primary tools.
That appears to be the logical conclusion based on the patterns of action and the stated aims found in the source materials. So if we were to synthesize the key findings from this deep dive, Antifa clearly isn't just some spontaneous modern trend.
No, the history is deep.
It's a militant movement with a history of subversion, with documented roots tied back to communist intelligence operations in the post-war era.
And its modern form relies on specific tactics.
Yes, it uses organized violence, tactical anonymity, that's the black bloc, and political intimidation methods like doxing. And all of this seems directed towards achieving radical political goals.
Goals that go way beyond just opposing fascism.
Right. They seem to aim for the total dismantling of the state, of capitalism, and of core Western institutions.
Okay, so what does this all mean for you, the listener? We've laid out this documented historical pattern: coordinated violence, clear ideological opposition to the U.S. system of law.
A consistent pattern over decades, adapted to new contexts.
So given the severity of these actions which seem to align pretty clearly with the definition of politically motivated violence designed to achieve a political end, does the formal legal status, that whole debate around the domestic terrorist organization designation, does it actually matter in defining the threat?
Or does the nature of their actions, the history of their actions, already define them regardless of the legal label? That's something to think about.
Yeah.
And the sources really drive home that connection we discussed earlier. The violence, the ideology, it's deeply rooted in the history of European radical political parties and their tradition of militant street action.
So the final thought, the takeaway for you to consider, might be this. What does this historical connection tell us? This link between far-left ideological goals like dismantling the state and the seemingly inevitable turn towards coordinated physical force, towards subversion, when groups try to achieve those revolutionary ends outside of the democratic or electoral process.
It's a recurring pattern worth examining closely. Welcome to the deep dive. Today, we're jumping into something pretty charged. Anti-fascist action, Antifa. We've got a stack of sources here. And they're really all over the map. Everything from a detailed histories by activists involved in street fights back in the UK, right up to recent U.S. government orders trying to label the modern movement a terrorist threat. So our mission, as always, is to try and pull these conflicting stories apart and, synthesize the key stuff for you, staying impartial.
Exactly. And the real puzzle here is, how does a movement that's so loosely affiliated, people involved often just call it an idea, how does that become the focus of a huge national security debate? We're going to trace it from its pretty organized militant beginnings in Britain through to its modern, more ideological form. And we'll look at the clashes over its tactics and even its legal status.
Okay, let's get into that history then. We actually start in Britain, not the U.S., with Anti-Fascist Action, or AFA. They were mainly active, 1985 to about 2001?
That's right. And they were consciously following an older British tradition of militant anti-fascism. Think back to the 1930s, the Battle of Cable Street. AFA formed specifically to take on groups like the British National Party, the BNP.
And when you say take on, what did that actually look like?
Well, their approach was defined as physical and ideological opposition to fascism. I mean, the groups they were targeting, like the BNP, weren't just holding meetings. They were actively selling racist papers on the streets, attacking minorities, attacking left-wing places.
Like that bookshop mentioned in the sources.
Yeah, the News from Nowhere bookshop in Liverpool is a known target. So AFA wasn't just about debating ideas, it was about physically stopping fascist activity.
And the sources suggest they were pretty effective, at least in some places. Liverpool comes up specifically.
It does. Apparently, the local BNP had been quite active, despite local opposition. But AFA's direct action tactics there were, well, decisive. We found this quote from the Liverpool BNP themselves, admitting they were, and this is their words, driven underground by left-wing extremists in the mid-'80s.
Wow. Driven underground. That's direct.
It was a deliberate shutdown. And it speaks to how AFA organized. They called it a militant united front. Intentionally broad, mostly anarchists and Marxists, people from groups like Red Action.
What held such different groups together in a united front?
The key thing was what they called the class perspective. The core belief was that fascism fundamentally aims to destroy working class power. Therefore, only the working class, organized and willing to fight, could truly defeat it. That was the ideological glue.
And they really did mobilize, didn't they? The sources talk about some major confrontations.
Oh yeah, this was their peak. They deliberately went where fascist groups were trying to gain ground or legitimacy, like Remembrance Sunday events challenging the National Front and BNP at the Cenotaph in London or Clifford's Tower in York.
Which has that historical resonance, the site of a medieval Jewish massacre.
Exactly. Showing up there was a direct challenge. And they had successes. They effectively smashed the Nazi music network, Blood and Honor, stopping their street sales and gigs around 1989.
And then there was the Battle of Waterloo in 92.
Right, a huge mobilization. The sources say over 1,000 anti-fascists turned up. It shows they were absolutely serious about controlling public space through physical presence and, confrontation.
Okay, but that raises a crucial question. If they were so effective on the streets, why did AFA eventually decline? Did that focus on physical action have limits?
It seems so. The sources point to a breakdown of that united front starting in the mid-'90s. It wasn't just one thing, but a major factor was a fundamental disagreement about strategy.
We do a little trolling. It's called we do a little
there were
trolling.
issues, like some anarchist groups falling out with Searchlight magazine, accusing them of being too close to police intelligence, special branch.
Mm-hmm.
But the big
do a little
split, the really
trolling. It's
decisive
called
one
we
was
do a
about
little trolling.
politics, specifically electoral politics.
Ah, right. This is the IWCA thing, the Independent Working Class Association.
Exactly.
We do a
After
little
the BNP
trolling. It's
actually
called we
managed
do a
to
little
win a
trolling.
local council seat in East London in 1993, one faction within AFA, led by Red Action, argued that street
We do a
fighting
little
wasn't
trolling.
enough.
It's called we
They
do a
said,
little
"Look,
trolling."
we need a political alternative. We need to stand for election.
And that didn't sit well with everyone.
Not at all. It basically tore the United Front apart. Many core AFA activists were fundamentally anti-electoral, anarchists especially. Others argued that AFA's strength was its single focus on direct action. Endorsing any political party would break that unity.
So the move towards trying to build an electoral party actually undermined the very thing that made AFA strong in the first place.
Pretty much.
Yeah.
And other factors chipped away too. The police definitely got better at handling their tactics. Activists got older, had families, maybe just couldn't sustain that level of confrontation. Plus, you had competition from other groups, like the relaunched Anti-Nazi League, which had more resources.
So AFA's centralized confrontational model eventually just couldn't hold. Which brings us across the pond and forward in time to Antifa as we hear about it today. How does that connect, and where did that specific name come from?
Well, the name Antifa itself is actually much older than British AFA. It's short for the German Antifaschistische Action.
Anti-fascist action.
Right. It was first used by the German Communist Party way back in 1932 as a banner to rally opposition against Hitler and the Nazis.
Okay, so the name has historical roots, but how is today's Antifa different from the organized British AFA we were just discussing?
And that's the crucial difference. Today, Antifa is generally understood as an umbrella term. It describes a far-left, anti-fascist political movement. It's characterized as a loose affiliation of local activists.
Right.
Critically, it has no designated leadership, no central organization like AFA had.
So it's more of an ideology, a set of practices, than a group you can join.
Exactly, which makes it fundamentally different to police or engage with. You can't just arrest the leader because there isn't one.
And the symbolism reflects that broad church, right? The famous logo.
Yeah, the two flags logo, one red for socialism or communism, one black for anarchism flying together. It visually represents that coalition, that umbrella aspect of the modern movement. Different far-left tendencies united against fascism.
Okay, this is where things often get heated in public discussion. The tactics.
Yeah.
Let's talk about the Black Bloc. What's the idea behind dressing in all black and covering faces?
The Black Bloc is a tactic, not a group itself. Activists wear black, use masks, bandanas, hoods, whatever conceals identity. The strategic purpose is twofold. One, anonymity. It makes it harder for law enforcement to identify individuals, especially if property destruction or clashes occur.
Like during the Trump inauguration protests in D.C. in 2017.
Precisely. That was a very visible example. Two, it creates a sense of unity and visual force. A uniform, anonymous bloc can appear quite intimidating. Sometimes individuals within the bloc might carry improvised weapons too.
And beyond street tactics, there's the digital side, like doxing.
Correct. Doxing is publishing someone's private information, online address, workplace, phone number, usually to expose them to harassment, get them fired, or generally disrupt their lives. It's been used against alleged white supremacists, for instance.
There was that case at the University of Nebraska, Omaha mentioned.
Yes. And on a larger scale, there was the incident in 2018 where an account linked to Antifa reportedly shared personal details of over 1,500 ICE employees. The goal there is clearly to intimidate and hinder the agency's work.
And for some activists, that level of disruption is seen as a measure of success, referencing the 1999 Seattle WTO protests.
For some anarchist extremists, yes. The massive property damage and disruption caused in Seattle back in '99 is sometimes held up as a benchmark, the so-called Seattle Standard, for successful direct action against state or corporate power.
Now, just quickly before we move to the terrorism designation debate, the sources mentioned something called national anarchists. What's that about? It sounds like a contradiction.
It is. It's a very fringe ideology, but worth noting.
Yeah.
Groups like BANA in California apparently try to use entryism, adopting the language and symbols of anarchism, environmentalism, anti-globalization, but for completely opposite goals.
So using the language to mask
white nationalism, basically. Racial separatism, wanting whites-only enclaves, which they term national autonomous zones. It's an attempt to co-opt anarchist aesthetics for far-right white supremacist ends. A fringe but confusing element.
Okay, right. So bearing all that complexity in mind, the loose structure, the mix of tactics, the ideological branding, how did we get to the point where the U.S. government was seriously trying to designate Antifa as a domestic terrorist organization?
Well, the political pressure ramped up significantly, especially around the protests in 2020.
We do a little trolling.
The Trump
It's called we do a
administration,
little
in particular,
trolling.
repeatedly blamed Antifa for violence and unrest. This culminated in an executive order signed in September 2025, according to our source here.
And what did that order actually say Antifa was?
It described Antifa in pretty stark terms, a militarist anarchist enterprise that, it claimed, explicitly seeks the overthrow of the U.S. government. It accused the movement of using violence, obstructing federal law, specifically citing attacks on ICE officers, and actively recruiting and training people to achieve its aims through coercion and intimidation.
That sounds very specific, like describing an actual organization. But given what we've said about Antifa being a loose movement, how did the legal side of that stack up? Can the U.S. government even designate a domestic group like that?
That's the core legal problem. Unlike with foreign terrorist organizations, there's currently no analogous mechanism in U.S. law to formally designate a domestic group. Legal experts, including former senior Justice Department officials, warn that doing so would raise huge, significant First Amendment concerns.
Because you'd essentially be outlawing an ideology or a political viewpoint rather than a specific group with a clear structure.
Precisely. Where do you draw the line? Who is in Antifa if there's no membership list? It becomes constitutionally very problematic.
And what about the intelligence? Did law enforcement actually find clear evidence that Antifa was the main driver of the violence in 2020, as was being claimed?
Well, the picture is more complicated than the political rhetoric suggested. Our sources mention an FBI report from the Washington field office in June 2020, which stated it had no intelligence indicating Antifa involvement in certain violent incidents during the George Floyd protests.
Really? So who did they think was involved?
Interestingly, the same intelligence reports did warn about far-right extremists, saying they had called for far-right provocateurs to attack federal agents and use weapons against protesters. So the intelligence picture on who was actually instigating violence seems much more mixed and contested than just blaming Antifa.
So the designation push faced legal hurdles and maybe wasn't fully supported by intelligence assessments.
Right. And this brings us back to history, in a way. This idea of the state defining and trying to dismantle or control an anti-fascist movement. It's not entirely new.
You're thinking about how states have sometimes used anti-fascism for their own purposes, like in East Germany, the GDR.
Exactly. In the GDR, anti-fascism wasn't just a grassroots sentiment. It became a central element of the state's official identity. It was almost a state religion, a propaganda tool.
How did they use it?
They used it to legitimize the socialist state, claiming they were the true anti-fascists, while painting West Germany and the West generally as inheritors of fascism. It helped justify the Berlin Wall, control internal dissent labeling dissidents as fascists, and generally bolster their position in the Cold War. It was highly functionalized.
And that framework, seeing the anti-fascist label used as a political tool by the state, is kind of how activists today view the terrorism designation attempt, isn't it?
Very much so. From their perspective, as cited in our sources, the designation attempt is a political tool, maybe even a distraction piece. They argue governments use it to demonize adversaries.
Their view being that genuine anti-fascist action is always seen as inherently threatening by the state.
Right. They'd say anti-fascists were always illegal in the eyes of the state because their actions challenge the established order, challenge police authority, especially if they feel the police aren't adequately dealing with far-right threats themselves. They see the designation as a political move to shut down opposition.
Okay, so let's try and synthesize this for everyone listening. We've traced this arc from a quite organized militant group, AFA in the UK, that had real success driving fascists off the streets locally.
But ultimately fractured due to internal politics and changing conditions.
Yeah, the modern Antifa phenomenon, a decentralized ideological movement or banner in the US using different tactics, which then becomes the focus of this intense political battle over whether it's a domestic terrorist threat. That difference between AFA, the organization, and Antifa, the idea, seems critical.
It really is. What emerges from the sources is that anti-fascism, whether it's organized like AFA or more of a diffuse movement like Antifa, consistently gets framed by its opponents, be they actual far-right groups or state authorities, as a dangerous threat that needs controlling, dismantling, or sometimes, like in the GDR, co-opting for state purposes. So the fight often seems less about the precise level of threat posed by, scattered groups of activists and more about the political power to define who the enemy is and what forms of political action are considered legitimate.
That leads perfectly into our final provocative thought for you. We talked about East Germany using anti-fascism as a state tool. But let's go even further back and into murkier territory. We found a declassified CIA report from 1952.
And it mentioned something called the Central Antifa School at Ogre, apparently located in what was then the Latvian Soviet Socialist Republic.
Ogre, Latvia. What was happening there, according to the CIA?
The report claims this school trained around 2,000 people, including former prisoners of war, specifically for subversive actions targeting Western countries. The program was apparently called a policy of persuasion.
Policies of persuasion, training people in Antifa tactics for subversion in the West, run by the Soviets in the early Cold War.
Exactly. So the question to leave you with is this. Across different times and places, has the label anti-fascism served a dual purpose? On the one hand, a genuine grassroots tool for resistance against real fascist threats, like AFA against the BNP, but on the other hand, has it also been at times a highly organized, state-sponsored instrument for espionage, political warfare, and subversion?
That potential duality, grassroots resistance versus state weapon, really adds another layer of complexity to understanding this whole phenomenon, doesn't it? Something to think about.
Welcome to the Deep Dive. We take complex source stacks, often polarized, and boil them down into the key insights for you. Today we're digging into a movement that's been around for decades, but has really hit the headlines recently. Anti-fascist action, often known now as Antifa. Our sources are, well, they're quite something. We've got everything from these really detailed, gritty accounts by activists in the UK back in the 80s and 90s, all the way up to current U.S. government documents, even executive orders trying to label the modern movement as domestic terrorists. So our job here is to unpack these clashing stories, look at the history, the structure, the controversies, and just lay out the different perspectives impartially for you.
Yeah, and the real puzzle, the core tension we're trying to get at is how does this kind of loosely connected social movement, I mean, people involved often say it's more an idea than an organization. How does that become the target of a major, like, executive level national security debate? So we'll trace it from its pretty organized and militant roots in Britain to the modern, much more decentralized form, and look at these really conflicting